for Kellips, if I've pronounced it correctly, if you'd work your way to the chair.
Hello, Your Honor.
Hello, can I have your name and date of birth, please?
I'm Mr. Trevan Goi, March 17, 1976, and thank you for getting my name right.
Thank you, Mr. Goi. Okay, I understand I have a lawyer from the state appearing on this case. May I please have appearance of counsel for the state?
Thank you, Your Honor. Brooke Gaunt on behalf of the state.
Thank you for joining us, Ms. Gaunt. Okay, Mr. Goi, you are here on allegations of new charges. The allegations against you are one count of making terroristic threats, that is a class 3 felony, and one count of computer tampering or use of a computer device to make a threat, that is a class 5 felony. I have found probable cause to support the making terrorist threats allegation. I am not inclined to find probable cause for the computer threat allegation. Based on my reading of the allegations against you, I did not see any allegation of a computer device used. Ms. Gaunt, before I officially make that finding, is there anything the state wishes to be heard on in regards to probable cause on the computer tampering allegation?
Not at this time, Your Honor. The state is not quite sure what the basis for that charge was, so we don't have any objection to the court finding no probable cause.
Okay, then I am finding probable cause for the terroristic threat class 3 felony allegation. I am not finding probable cause to support the class 5 felony computer tampering allegation. Mr. Goi, I have determined that you are entitled to a court-appointed lawyer, and I have appointed the public defender's office to represent you. Your next court hearings will be a status conference September 24th, and then you will have a preliminary hearing September 26th. Both of those hearings will be at 8:30 in the morning in the Superior Court downtown. Before I consider or impose release conditions in this case, may I please hear argument or recommendation regarding release from the state? Ms. Gaunt.
Thank you, Your Honor. The state is asking for a $500,000 cash-only bond, and if Mr. Goi is able to post that, we'd ask for electronic monitoring. That request is based on the severe nature of these charges. Mr. Goi allegedly contacted the crisis line and advised that he intended to shoot up a gay bar and specifically identified a location near his residence. Additionally, he told the crisis line that he wanted to send a political message and he said further things, anti-trans people's statements. He referenced the recent shooting of Charlie Kirk and several other recent school shootings. Law enforcement also confirmed that previously on September 7th, he had contacted 911 and at that time advised that he intended to shoot bystanders. We are very concerned that Mr. Goi has some mental health issues and that he is given these threats to not only target specific people, but also to shoot innocent bystanders. We are concerned that he's extremely dangerous and believe that that significant bond is necessary to protect the safety of the community. Thank you.
Thank you, Ms. Gaunt. Okay, Mr. Goi, the state has requested that I hold you on a $500,000 cash bond based on their representation that the facts alleged in this case indicate that you potentially pose an extreme danger to the community. I will give you an opportunity to present any information you wish for me to consider in regards to your release conditions. Before I give you that opportunity, I will tell you or remind you, you do not have a lawyer here in the court this afternoon. As you can see and hear, the state's lawyer is present. Anything that you do say now could be used against you in this case going forward. So I will give you an opportunity if you would like to address the court in regards to release conditions. You have that opportunity, but I caution you very strongly to limit your comments in regards to release conditions. I very strongly encourage you not to talk about the facts of this case because you don't have a lawyer present. Is there any information you would like the court to consider in regards to your release conditions?
Just that it was just an overreaction to something political.
Okay, so it sounds like you either dispute or disagree with the underlying factual allegations or think that you might potentially have a defense to those. That is completely fine. You have every right to explore both of those avenues. That will be done through your lawyer starting at your next court hearing. For purposes of this hearing today, though, I am persuaded that the allegations against you do appear to indicate that you pose a substantial risk of harm to innocent members of the community. I am concerned about targeted threats alleged to have been made against certain types of populations in the community, and I feel strongly that people in the community, regardless of any of their identifying factors, have the reasonable expectation to feel safe where they go. I think that the allegations posed in this case pose a substantial risk or threat to that safety. Because of that, I am persuaded that a substantial bond is necessary in this case. I am going to set a $250,000 secured appearance bond. If you post that bond prior to your release from custody, you will be affixed with an ankle monitor for electronic monitoring. You will also be under strict house arrest. That means you cannot leave your house without prior approval from pretrial services, and under those circumstances only as are authorized by pretrial services. So you could not leave your home without their permission, and upon leaving your home, you could only go to the locations that they authorize you to go to. Anything else I need? Oh, also, if you're released from custody, you are absolutely prohibited from possessing any weapons under any circumstances. Anything else I need to address before I excuse this matter, Ms. Gaunt?
No, Your Honor. Thank you.
Thank you, Ms. Gaunt. Okay, Mr. Goi, do you understand those release conditions?
I'm in custody because I can't make them.
Okay, but do you understand what they are?
Yes.
Okay, thank you very much, sir. You can step back and
I do need medication. My life is at risk.
Okay, so here's what you'll do. So long as you remain in custody, your medical care is the responsibility of the sheriff's office. So if you do not post that bond, you will not stay here at this facility. You'll be transferred to a facility that is more permanent, has beds, better food. When you get to that other facility, well, even here, communicate to jail staff that you need medication or that you need to be seen by mental health. They will make arrangements for any medical needs that you express to them. Anything else, Mr. Goi?
That's it.
Okay, thank you, sir. You can step back and get your paperwork. Officers, if you would clear for me, I would greatly appreciate it.
Anyone forget a hat? Clear, Your Honor.
Okay, Christopher Kellips, if you would please work your way into the courtroom. Can I have your name and date of birth, please, sir?
Christopher Kellips, 1/28/76.
Thank you very much, Mr. Kellips. And I believe that the state's lawyer also wishes to appear on this matter. Appearance of counsel for the state, please.
Thank you, Your Honor. Brooke Gaunt, on behalf of the state.
Good afternoon again, Ms. Gaunt. Thank you for joining us. Okay, Mr. Kellips, you are here on allegations of new charges. The allegations against you are 10 counts of sexual exploitation of a minor, all Class 2 felonies. Based on my reading of the information provided to me by law enforcement in an addendum to the Form 4, I am inclined to find probable cause to support these allegations. Ms. Gaunt, any objection or additional information the state wishes me to consider in regards to probable cause?
No, Your Honor.
All right, then I do find probable cause to support those allegations. I have appointed a public defender to represent you. Your next court hearings will be a status conference September 24th, and then you will have a preliminary hearing September 26th. Both of them will be at 8:30 in the Superior Court downtown. Before I consider or impose any release conditions, may I please hear argument and recommendation from the state?
Thank you, Your Honor. The state's asking for a $150,000 cash-only bond, and if Mr. Kellips is able to post that, we'd ask for electronic monitoring as is required by statute, no contact with any minors, and no internet use. These requests are based on the nature of the charges. Mr. Kellips allegedly was in possession of child sexual abuse material. Not only did he access the internet to obtain this material in Arizona, there are also allegations that he did so while in Wisconsin visiting his family. We are concerned that he's a danger to the community given these allegations. Additionally, given that he has family in the state of Wisconsin, he is also potentially a flight risk. Thank you, Your Honor.
Thank you, Ms. Gaunt. Okay, Mr. Kellips, the state, as you have heard, has asked for you to be held on a $150,000 cash bond. It sounds like their primary concerns are that you pose a substantial danger to the community and that you could potentially pose a flight risk. You have the opportunity to address the court before I impose any release conditions. I will give you that opportunity, but before I do that, I want to remind you, you do not have a lawyer present here in this hearing. As you can see in here, the state's lawyer is present. Anything that you do choose to say could be used against you. So I will allow you to address the court in regards to considerations of what release conditions I impose, but I will very strongly caution you to try to limit your remarks to release conditions. I caution you very strongly to avoid going into the factual allegations of this case until you're at a hearing with a lawyer present. Okay, Mr. Kellips, if you wish to present any information to the court regarding what release conditions should be imposed, now's your opportunity to do that.
Just that I work and I wouldn't be a flight risk. I haven't gone anywhere, so I wouldn't do that.
Okay. All right. Thank you, Mr. Kellips. I have reviewed the factual allegations in this case. I am persuaded that based on those allegations, there is a substantial risk of harm, specifically to minors in the community. I do note, Mr. Kellips, that you have one prior failure to appear at a court hearing, but I do not show any criminal history in regards to felony criminal allegations. I am persuaded that a bond is appropriate in this case. I am going to set a $150,000 secured appearance bond. That means you have the opportunity to use a bonding company to post that. Under Arizona law, you are required to wear an ankle monitor if you post that bond and you are released from custody. So if you post that bond, you will be released on an ankle monitor. If you are released from custody, you cannot have contact with any minors. You would also be prohibited from accessing the internet through any electronic means. If you are released from custody, you also could not possess any drugs without a valid prescription. Anything else I need to address from the state's perspective, Ms. Gaunt?
No, Your Honor. Thank you.
All right. Thank you, Ms. Gaunt. Mr. Kellips, do you understand those release conditions?
Yes.
Okay. Thank you very much. You can step back and get your paperwork. Ms. Gaunt, you are free to disconnect if you wish to. Thank you for joining us.
Thank you, Your Honor.
Okay. Number 19 on the calendar, Deshaun Johnson, date of birth 9/28/2004. Is not in the courtroom because he was unable to function in general population and refusing orders. He is here on a bench warrant issued by the Superior Court when he failed to appear at a status conference in an existing felony case involving resisting arrest allegations. He already has a lawyer assigned to him in that case. That lawyer will continue to defend him. His next court hearing will be a status conference September 24th at 8:30 in the Superior Court downtown. On that warrant, he has a $500 secured appearance bond. Number 23 on the calendar, Raone Dominguez, date of birth 5/1/92, is not in the courtroom because he was unable to function in general population and refusing orders. He is here on a failure to appear warrant issued by the Santan Justice Court on a misdemeanor driving on a suspended license allegation. Because it's a misdemeanor allegation, he's not entitled to a court-appointed lawyer. His next court hearing will be an arraignment hearing October 7th at 9 o'clock in the Santan Justice Court, and I do intend to release him on his own recognizance. Last on the calendar, number 30, Rusty Gallow, date of birth 4/24/2006. is not in the courtroom because she was unable to function in general population and exhibiting inappropriate behavior. She is here on a failure to appear warrant issued by the Santan Justice Court on a misdemeanor assault allegation. Because that underlying allegation is a misdemeanor, she's not entitled to a court-appointed lawyer. Her next court hearing will be an arraignment hearing October 7th at 9 o'clock in the Santan Justice Court, and I do intend to release her on her own recognizance. If anything changes after I visit any of those individuals cell side, the court's orders regarding their release conditions will be reflected in their written release orders. That concludes the 2 p.m. initial appearance calendar. This court will stand in recess until 5 p.m.